Family, Central Florida dad killed in front of 8-year-old son amid tree trimming dispute with a neighbor. Awful. Just awful. There's the suspect on the left, the killer, Edward Drezolowski, and there's the victim, Brian Ford. So 78-year-old the Leon Springs man is in jail without bond, accused of shooting and killing his neighbor during a dispute over trees. Edward Drezolowski is charged with second-degree murder in the death of 42-year-old Brian Ford. I don't know if Steve Gosney's in the chat. He's our local Florida criminal law expert. In some states, second-degree murder is effectively the highest degree of murder without going to a capital crime, without putting capital punishment on the table. And capital punishment greatly complicates a prosecutor's efforts at trial and leading up to trial. So often prosecutors will decline to pursue a capital murder case simply because it increases the complexity of the case for them. I'm not sure if that's why we were looking at second degree here as opposed to something else. Nevertheless, 911 calls were released Monday. Reveal it was the suspect's wife who called for help. So the shooter's wife. The sheriff's office also released body cam video showing his arrest. Quote, "My husband had it in his hand. He meant to scare him," meaning the gun that was used, presumably a revolver, as we'll see. "He meant to scare him and he hit him. He was on our property," meaning the victim, or maybe meaning the husband. They were both on the shooter's property. The victim's mother tells a harrowing story. Her son was trimming tree limbs for her when he was shot and killed in front of his 8-year-old son. Oh, so the tree trimmer was at his mom's house, basically neighbor to the shooter. She says she and her neighbor weren't exactly friendly, but never expected something like this. The son said, "He shot my dad. He was screaming, 'He shot my dad.' And he wanted to go over and lay on top of his dad's body." Linda Ford, the mother of the victim, said. Then some emotional stuff here. "I heard a big boom and then he started, the son, 'He shot my dad. He shot my dad.'" Okay. Drezolowski let his court-appointed public defender plead his case for bond, telling the judge that he had no prior criminal history, but Assistant State Attorney Dustin Haven argued against it. He admitted and was unarmed and had made no threats. That's actually contested, as we'll see. There is testimony from the victim's own son, the 8-year-old, that his father had threatened the shooter with death immediately prior to the shooting taking place. According to the sheriff's office, the suspect saw the victim doing the tree work and ordered him off what he claimed was his property. Though the victim's mother told the TV media that her son was still on her property. "My fence is 2 feet inside my yard, so I go another 2 feet outside my fenced area." Who knows, right? Somebody will have to make a factual determination. In my experience, it's not that common for people to put their fence up 2 feet inside their property line. But when the victim didn't leave, the tree trimmer, investigators say the suspect shot him. The victim's mother says the suspect was still holding the gun when she got there and pointed it at her and her grandson. He kept pointing the gun at him. He said, "Shut up, kid," to him. And then Ed was pointing the gun at me. He was walking towards the fence line and I backed up and I was screaming through the yard. And that's the whole news story. All right. Let's turn now to Professor Turley's write-up here. And there's Professor Turley on the right. Good-looking gentleman. And Edward Drezolowski on the left, a less good-looking gentleman. So Edward Drezolowski, 78, is facing a second-degree murder charge in Florida after gunning down his neighbor over a tree-cutting dispute. Brian Ford, 42, the victim here, was on Drezolowski's property. So Professor Turley is saying, contrary to what we just saw in the news report, that the claims by the victim's mother, that in fact the victim here was on Drezolowski's property. So we'll go with that presumption moving forward just because it's the context in which Professor Turley wrote this blog post. Brian Ford was on Drezolowski's property, trimming limbs from a tree between their property when Drezolowski told him to leave. What unfolded led not only to murder charges, but may lead to a controversial defense. That's really what we're here to talk about. So according to the sheriff's office, Drezolowski said that he was watching football on Sunday night when his wife told him that Ford was on their property cutting branches. He said he was afraid of Ford because Ford would talk about his doing time in prison and fighting other inmates. Okay, would that be evidence relevant for admission at trial? Sure. I mean, presumably, Drozalowski is going to be claiming self-defense as his legal defense, his justification for the shooting death of Ford here. And of course, if you're claiming self-defense, you have the up to 5 elements of self-defense, one of which is reasonableness. Your fear of imminent harm has to be a reasonable fear. That's a subjective and objective state of mind. But for the subjective component, your knowledge of that other person's reputation, history of violence, that you knew at the time you acted in self-defense is absolutely relevant evidence that would be admissible at trial. Now, if you learned of that character for violence after you acted in self-defense, it might well likely not be relevant for admission because it did not inform your subjective state of mind in acting in self-defense at the time. Drozalowski told the police that he brought the gun for protection, even though they had never had problems in the past. Well, okay, you're going to have a problem now, right? You're going to a confrontation. You know you are. Someone's on your property, which is unlawful. They're not there by license. It's trespass. And you have knowledge that that person has a character for violence. So being armed doesn't strike me as unusual. Now, frankly, I would be armed anyway because I'm always armed. I wouldn't be grabbing a gun just to go out and confront this person. I'd already have a gun on my person because that's my normal state of being. Drozalowski said that he told Ford to get off his property and that Ford cursed him and told him to mind his own business. What are we not seeing here? Any testimony that Ford claimed that he was actually on his mother's property and not on Drozalowski's property. Drozalowski then pulled his gun and pointed it at Ford. He said that Ford was undeterred and said, "You are pointing a gun at me. Are you going to shoot me?" All right, so here we have already an interesting question. Before we even get to Professor Turley's analysis, this pointing of the gun. Let's assume we have a simple trespass taking place. So someone's present without license, but not with malice, not to commit some further criminal mischief. They're simply present without license. So a simple trespasser, can you use force to remove a simple trespasser from your property? Yes, you can. You can only use non-deadly force to do that. So you can't simply shoot a trespasser. That's true everywhere in the United States. You could grab them by the arm if they are non-compliant with your orders to get off the property and use non-deadly force to remove them from the property, but not deadly force. Did Drozalowski use deadly force to attempt to remove Ford as a trespasser? Well, of course, we know eventually a shot was fired, but that's purportedly in response to some further threat by Ford. In the context of simply attempting to remove a trespasser, is the pointing of the gun at the trespasser the use of deadly force? Well, courts vary on this question. Most courts in most jurisdictions will hold that use of the firearm means discharge of the firearm. That merely pointing of the firearm is not a use of deadly force. It's a threat of deadly force, but it's not a use of deadly force. So we'd have to see how Florida treats this kind of dynamic. Now, can you threaten deadly force against a simple trespasser, even if you don't intend to actually use it? And imagine you never do use it. All you ever do is a threat. Is that aggravated assault with a deadly weapon? You've put them in subjective fear of imminent deadly force harm, presumably, right? By displaying the gun.